Accidentally started dating my client's wife, unknowingly entangling myself in their divorce proceedings, and now everyone involved is rightfully furious. A couple of months ago, I found myself living through a situation so unbelievable, I had to do a double take when I saw a comedy skit online that mirrored my experience almost exactly. For some background, I'm a divorce attorney and have been working in family law for about 8 years. Most days, my work follows a routine. People come in wanting to unravel their marriages, I chart their course through the legalities, and everyone moves on with their lives. Let's rewind to last March. I picked up a case that, at the outset, seemed perfectly straightforward. My client, let's call him Dave, was a decent guy who had already been separated from his wife for over a year. He just wanted the paperwork and closure. No knockdown, drag out, property fighting acrimony, just a clean split. The retainer was fair, the paperwork simple, and I figured we'd have it finished up in a couple months at most. At that same time, a woman named Sarah came into my life. We met at a cozy coffee shop near my office and hit it off from day one. She mentioned she was going through a divorce, but I didn't dig too deep. It's not exactly what you want to bring up over lattes on a first date. Her last name wasn't one I recognized, and when I ran my standard conflict checks for new clients, nothing in my files raised any red flags. Life with Sarah was good. Really good. We were taking things slow, but there was this effortless chemistry and every date left me grinning like an idiot. All of that came crashing down the day I was scheduled for my first in-person, four-way settlement meeting for Dave's case. I walked into the conference room, talking with Dave about how we'd keep everything civil and make this as painless as possible. Then I saw her, Sarah, sitting across the table, looking like she was about to faint, with her own attorney by her side. I froze mid-sentence. My briefcase slipped out of my hands, smacking the floor with a sound that shattered the silence. Sarah went sheet white. Dave glanced back and forth between me and her, his eyes shifting as understanding slowly dawned. That instant when it finally, painfully clicked for him, he just stared at us and asked, with a deadly calm, "Are you fucking serious right now?" Not yelling, but every word sharp as a knife. Sarah's eyes brimmed with tears. Her lawyer looked like he'd sell his soul to disappear. And me? I stood there feeling like the dumbest man alive, caught in this collision of professional and personal disaster. I had to pull Dave aside immediately. He was rightfully pissed, grilling me about how long I'd known Sarah, whether this was some kind of twisted setup, if I'd engineered this situation to undermine him. I explained, truthfully, that I had been dating his wife for a couple months but had no idea who she was. Her last name on her file didn't match the one I knew. He wasn't buying it at first. All he kept saying was, "What kind of lawyer doesn't ask basic questions?" Desperate, I pulled out my intake notes, walked him through my conflict check process, and basically had to convince him that, yes, I was an idiot, but not a villain. It took a solid 20 minutes for him to accept it was just a case of stratospherically bad luck. Even then, he just shook his head, muttering about how screwed up it all was. When he calmed down, I explained that I had to withdraw from his case. There was no way around it. Having a personal relationship with the opposing party meant I couldn't represent him properly. Dave wasn't happy about losing his lawyer and having to start over, but he got why it had to be this way by the end. As we wrapped up, he told me, "This is the weirdest goddamn thing that's ever happened to me." The aftermath was brutal. The paperwork alone was a nightmare. I had to file a motion to withdraw since litigation had already started, transfer his files, refund unused fees, the works. Sarah and I didn't speak for nearly 2 weeks after that train wreck of a meeting. The embarrassment was bone deep for both of us. Even her attorney spent ages working through his suspicion that maybe this had all been some elaborate ruse. No matter how accidental it was, the responsibility was mine. My conflict check had failed. That's on me, and I knew it. In this business, your mistakes have consequences. Dave texted me after a few weeks, not to patch things up but more to vent. "Hope you realize this completely fucked up my timeline." I couldn't blame him, and as a final kick in the teeth, my malpractice insurance premium shot up when I had to report the conflict. Sometimes, the universe just decides you're going to star in a cautionary tale. Update 1. It's been about 7 months since the conference room incident, and the aftermath has been nothing short of chaotic. About 3 weeks after I withdrew from Dave's case, I was summoned to a meeting with the senior partners. Picture this, 3 partners, our firm's general counsel, and a representative from our malpractice carrier glaring at me through a video call. The managing partner slid a thick folder across the table toward me. Opposing counsel reported a conflict of interest issue to the state bar under Rule 8.3. We've been notified of a disciplinary inquiry. That simple sentence sent a bolt of panic straight through me. Dave's new attorney had filed a report. I knew they weren't the ones who'd decide the outcome. They were just obligated to report the possible violation. Then the bar stepped in. I laid everything out, all the details, how I met Sarah, how we'd been casually dating for a couple of months, the fact that she used a different name socially. My conflict check on her legal name hadn't raised any red flags, because I never realized the connection. As the general counsel took notes, she asked me to walk her through my conflict check process. I explained our intake procedures, how the system worked, how I simply didn't connect Sarah with her legal surname. It all sounded so much worse out loud. This is a clear model Rule 1. 7a, 2, issue, a material limitation conflict, she said. You were correct to withdraw under Rule 1:16, but we need to understand how this wasn't caught earlier. Then the malpractice carrier's rep unmuted himself. We'll need to document this as a circumstance that could lead to a claim. It'll be noted when your policy comes up for renewal. Perfect. The fallout kept coming. The firm required me to complete an 8-hour CLE on conflicts of interest before I could intake any new clients. They already had me registered for a seminar that Saturday, 8 in the morning. Naturally, when I showed up at the hotel conference room, there were about 20 other attorneys, none looking particularly thrilled. One of the instructors was Patricia, a divorce attorney I'd opposed before. The look she gave me told me she knew exactly why I was there. For the first few hours, it was standard review, rules, case law, procedures. But then we reached the case studies segment, and Patricia brought up Henry Johnson, a 2019 disciplinary matter. Attorney representing a divorce client starts dating someone only to discover, at a settlement conference, that it's the opposing party. The exact situation I'd been involved in, down to the last excruciating detail, except this case happened 6 years ago in a different state. I wished I could just melt into the carpet. Lunchtime couldn't come soon enough. At the sandwich table, another attorney chimed in that he'd heard about a similar conflict at a firm in town recently. He didn't know it was me, but it was obvious the story was spreading. I survived the seminar, passed the exam, and returned to the firm with my little certificate in hand. A few weeks later, the state bar sent me a letter. The inquiry was closed with a private caution. Just a warning, something that would stay in their files but not become public discipline. It could have gone much worse. Of course, my malpractice premium shot up about 15% when it renewed in September. The carrier specifically cited the reported disciplinary circumstance in the letter. The firm rolled out new procedures just for me. For the next 6 months, I couldn't take on a new client until I got a pre-clearance from the general counsel. They also overhauled our intake forms, adding mandatory fields for nicknames and AKAs in the conflict check system. But honestly, none of that's the worst part. The worst is knowing that people around the bar know. Not everyone, but enough. Twice now, I've been called the coffee shop lawyer at bar events. Last month, opposing counsel asked with a sly grin if I'd met the other party before. The story is definitely making the rounds. Some versions have me engaged to Sarah, others claim I didn't find out until trial. It's becoming one of those cautionary tales told over drinks. I haven't dated anyone since March. I deleted all the apps. I still glance over my shoulder, expecting to hear a whispered punchline. Update 2, I thought the worst of it was over. I had my little private caution letter from the bar stuffed in a drawer. I'd done my penitential CLE hours, and the nickname thing had almost stopped at happy hours. Then, 2 Fridays ago at 7:42 a.m., a process server knocked on my apartment door while I was standing in pajama pants waiting for my coffee to finish. He handed me a manila envelope and said, "You've been served, with that particular blend of apology and amusement people get when they know a story and you're the punchline." It was a subpoena duces tecum and a deposition notice. Dave's lawyer wanted my phone records, texts, and any communications concerning the marital relationship of David, redacted, and Sarah, redacted, including but not limited to the timeline of separation and any instances of cohabitation. They also wanted my intake notes, my conflict check printouts, and any and all calendar entries referencing encounters with Sarah, redacted. The deposition was set for the following Thursday at 9. The cover letter was a masterclass in polite menace. I called our general counsel before my coffee was done brewing. She sighed, told me to preserve everything immediately, and looped in outside counsel to represent me personally. By noon, an e-discovery vendor was sitting in a conference room with me and a right blocker hooked up to my phone, imaging my texts while I tried not to think about how many dumb memes live in my messages app. The vendor, a very kind woman named Tessa, asked me to confirm date parameters while she scrolled. Seeing my own name nestled next to Sarah's in thread after thread felt like watching a time-lapse of a bad decision. We moved to quash part of the subpoena. Privilege was the big line in the sand. Anything I learned from Dave while I was his lawyer was off limits. But communications with Sarah weren't privileged. We argued undue burden, relevance, scope. There was a quick hearing on an emergency basis the day before the deposition. The judge, who I've been in front of maybe a dozen times, looked at me over the rim of her glasses and said, "Counselor, you are here as a witness today, not as an advocate. Breathe." Then she split the baby. No production of internal firm intake forms or conflict check algorithms. Yes to my personal communications with Sarah about the timeline. No to broad fishing into my social life. Yes to my calendar entries, limited to any dates I was at her house. The deposition itself felt like being dissected with butter knives. We were in a bland conference room with a half-dead fern and a box of Costco pastries. On one side of the table, Dave, his lawyer, and a second chair I recognized from the CLE as Patricia. On the other, Sarah, her attorney, and a paralegal who kept her eyes on the transcript like it was going to hatch. My counsel sat beside me, hand hovering over her notepad like a pitcher waiting for the sign. I got sworn in, and the first question out of Dave's lawyer was, "State your name for the record." The second was, "When did you first meet my client's wife?" It only got more intimate from there. There is nothing quite like answering, under oath, whether you spent the night at subject residence on specific dates while your old client stares at you like you're a spreadsheet that ruined his life. They tried to get me to peg the relationship to particular weekends using Uber receipts and my phone's location history. Tess's data pull meant they had a log of every time I'd late night Ubered to Sarah's neighborhood. My counsel objected to a handful of questions as calling for privileged information when they veered into what I knew about the separation from my representation of Dave. There were a lot of objection, privilege. Do not answer. There were also a lot of answers that began with, to the best of my recollection. I could feel Patricia watching me like she was adding footnotes to the CLE slide deck in her head. At one point, Sarah's attorney took over and tried to soften the edges. Did you ever discuss with Sarah the legal implications of dating while separated? No, I said, and for once it felt good to be able to say it cleanly. We did talk about movies and dogs and the best bakery in our neighborhood. We did not talk about alimony factors. 2 hours in, Dave's lawyer slid a printed screenshot across the table of one of my texts to Sarah. I'm in a client meeting, can't talk. See you at 7. The timestamp put it on the day of the four-way. I did not vomit on the transcript, which felt like surprising personal growth. She asked if I knew at that time she was the opposing party. No, I said. I learned that approximately 20 minutes later, when I dropped my briefcase in front of all of you. The court reporter did not look up, but I swear I heard her smother a laugh. We finished with a question I had been dreading. Did you, at any time, disclose to Sarah information obtained through your representation of David, redacted? My counsel's hand went to my forearm the way you steady a table that's about to wobble. No. That one was easy. I hadn't, and I would have deserved to be disbarred if I had. I walked out of there and sat in my car and just stared at the dashboard for a minute. My phone buzzed with a calendar notification reminding me to attend section lunch, lawyers as witnesses and Rule 3. 7. Whoever picked that title has a sense of humor. Because apparently, the universe didn't think the deposition was enough, either. I got called as a live witness at a temporary support hearing the following week after the judge decided she wanted to hear from the horse's mouth before ruling on fault and support. Being addressed as Mr., my last name, by a judge who usually calls me counsel landed in the gut. The judge set my parameters herself this time. Nothing privileged, nothing beyond the narrow question of whether my relationship with Sarah predated her separation, my testimony to be considered only as it bears on support. If you've never had opposing counsel try to impeach you with your own calendar entry titled Sarah, tacos, count your blessings, I was on and off the stand in 15 minutes. The judge took it under advisement and issued an order a few days later. 2 sentences from it punched a hole straight through my hope of officially fading into obscurity. The court notes that plaintiff's prior counsel withdrew due to a personal relationship with defendant, as reflected on the docket. The court considered testimony from prior counsel for the limited purpose of establishing timeline of cohabitation and dating. There it was, not my full name in the body, but the docket is public. Anyone with a login and a grudge can go fishing. There was one human moment in the middle of all this that I still can't quite categorize. After the hearing, in the hallway outside the courtroom, Dave fell into step next to me. We walked in silence to the elevator. The doors closed, and he said, I meant what I said back then. Weirdest thing that's ever happened to me. Then, after a beat, thanks for answering the question straight, no sarcasm, no heat. When we hit the ground floor, he stepped out and was gone before I could decide whether that was forgiveness or just fatigue. 2 days later, our managing partner told me I'd been volunteered to deliver a lunchtime presentation to the associates on conflicts hygiene. 30 minutes, brown bag style, my choice of materials. I didn't use my story directly, I didn't have to. I had them imagine hypotheticals that weren't hypothetical, and watch them scribble notes like their pens were on fire. Afterward, one of the first years asked me if I ever thought about just leaving family law altogether. I looked at the carpet and said, every other Tuesday. Yesterday afternoon, I got an email from an unfamiliar address with a PDF attachment, a scan of a final decree signed and file stamped. No body text, just the decree and the signature block. The sender was Dave. There's a footnote on page 2 where the judge memorializes counsel withdrawal and the narrow admission of my testimony. I stared at the slick little superscript 1 like it was a birthmark I'd somehow grown. Then I scrolled to the bottom. Under his digital signature, Dave had typed one sentence, finally done. Update 3. 3 days after Dave's finally done email, I got an e-file notification that made my stomach clench like a bad elevator drop, a motion for fees tied to the additional discovery and my deposition. Not sanctions, just a neat little request that the court allocate costs necessitated by the conflict circumstance. It read clinical until you hit the exhibit tabs and saw the court reporter invoice clipped to a transcript where I am, for posterity, identifying whether Sarah, tacos meant dinner or an actual event. We had a short hearing the following week. Same courtroom, same thin microphones that make everyone sound like they're speaking from inside a paper towel roll. The judge walked in with a stack of files under one arm and the kind of expression that says she is already out of patience for everyone. Dave's lawyer argued the equities. Sarah's lawyer countered that they didn't ask me to date anyone and they didn't schedule my deposition for fun. My counsel squeezed my elbow once under the table and told the court, evenly, that I wasn't a party and had complied with the subpoena without gamesmanship. The judge rubbed the bridge of her nose and said, "No one is getting sanctions out of this. The court will not order a non-party to pay fees in these circumstances." Then she looked over her glasses at me and added, "However, counsel, if you feel moved to compensate the court reporter for the extra hour caused by your answers being longer than necessary, that would be good manners, not law." I wrote a check for the overage before I left the building and handed it to the reporter in the hallway. She blinked, then said, "I'll note that." Nowhere. That same afternoon, my phone lit up with a text from an associate, "Lol, you made above the docket." It was a link to a legal gossip blog with a headline that managed to be both wrong and devastatingly accurate. Family lawyer testifies against own client after dating opposing party. Don't be this guy. The piece didn't name me or the firm, but it quoted the support order and you didn't need to be Sherlock to triangulate. I read it standing by a window that looks out over a parking garage and thought about the custodial staff who would have to vacuum up the ghost of me if I spontaneously evaporated. Then I got a voicemail from Dave. It was 12 seconds long. Saw the article. Wasn't me. Figured you'd want to know. I saved it. I don't know why. 2 days later, our general counsel forwarded me an email from the bar's practice management section. They were convening a bench bar roundtable on conflicts in small communities, and someone on the planning committee had suggested I might have useful practical perspective. The invitation landed with a thud of irony so heavy it should have cracked the floor. I went. They put us in one of those hotel conference spaces that always smells faintly of coffee and industrial carpet cleaner. Metal carafes lined up like chess pieces, a plate of cookies sweating under cling wrap. Across the U-shaped table, 3 judges, a handful of old lions, a scatter of mid-career attorneys who traded billable hours for free pastries, and Patricia. She didn't wave. She raised her eyebrows as if to say, "So this is our lives now." The moderator opened with anonymized scenarios. The second one was not anonymized enough for me to feel like a human person. The judge who'd presided over my hearing cleared her throat and said, "People live in neighborhoods. They go to coffee shops. We cannot rule human contact unethical. But we also cannot pretend it has no implications. Our intake systems should reflect the world we actually practice in." Heads nodded. I found my voice long enough to suggest that firms add prior names use socially unknown handles/AKAs to conflict checks. A mediator from the other side of town proposed capturing associated phone numbers for a one-way hash match. Someone from a legal tech company at the end of the table scribbled like their pen was on fire. The GC conscripted me to beta a stupid little tool I wrote in a weekend that cross-referenced my Outlook contacts, calendar, and the firm's conflict database for overlap on first names plus neighborhoods plus phone area codes. We called it the "Oh no" script because that's exactly what it made people say. The first real test wasn't mine. On Tuesday morning, a second year wandered into my office gray around the edges and held up her phone. The script had pinged on a Bumble date she'd planned for Friday. His last name matched the surname of an opposing party in an active custody fight. Not the same person, but the right brother. The client had mentioned a brother living downtown. We closed the loop with GC and flagged it to the team. The second year sent me an email with 9 exclamation points in the subject line and 2 words in the body. Didn't go. There was this small, improbable feeling in my chest I hadn't had in months. Useful. There were human moments, too. I was walking out of the courthouse one afternoon after the roundtable when I saw Sarah sitting on a stone bench by the steps, a manila folder tucked under her arm like a clutch. She stood when I got close. We hovered in that 3-foot space that belongs to people who used to know each other. She said she wasn't there for anything dramatic, just filing a name change order, the legal back end of the new life you print on change of address forms. She was moving to Portland for a job. I told her I hoped the rain liked her. She handed me a paperback I'd forgotten was mine, the spine soft and frayed at the corners. A receipt from the coffee shop where we met slipped out and skated onto the concrete. We both reached for it, the choreography of an old joke, and then didn't know what to do with our hands. She said, "I'm sorry." I said, "Me too." That was all we had for each other. It felt right. A week later, I was in the cheap seats at a minor league game with a friend from law school, doing the thing people do when they want to be near joy but not responsible for making it. Between innings, my phone buzzed with an email from intake assigning a consult for a postnup. The referral line read, "From Dave, redacted." I stared at it until the national anthem. I sent it to a colleague down the hall with a short note, "Warm referral. Please take." 5 minutes after first pitch, my colleague poked his head above our shared cubicle wall in digital form. 1-line reply, "Wild universe." I agreed. I thought that would be the strangest thing that happened that week. Then the Family Law Reporter published a short opinion on an appeal in Dave's case, narrow issue on support calculations, nothing earth-shaking. The panel affirmed. Third paragraph, a footnote that should have just been numbered me. We note the trial court admitted limited testimony from husband's prior counsel regarding the timing of wife's post-separation relationship, for the restricted purpose stated in the order. We find no abuse of discretion. It wasn't my name, but you could hear it echo. That's the way immortality arrives for people like me, not with trumpets, just with a parenthetical. 2 days ago, I walked into a windowless conference room at the firm with a dozen associates and a plastic tub of hummus to do my penance lecture on conflicts hygiene. I said hypothetical like it owed me money. I watched them write down ask for prior names and nicknames matter. Afterward, a first year hovered by the door and told me she'd started putting what name do you go by at the DMV? On her predate small talk as a joke that wasn't entirely a joke. I didn't know whether to laugh or burst into tears. Last night, for the first time since March, I said yes to a drink with someone I didn't meet in a courthouse. We picked a place that doesn't have any chance of hosting a settlement conference. I asked for her last name early, and then, because my mouth is permanently wired to the ethics outline, I asked if she'd ever gone by anything else. She blinked, then smiled in a way that said she had decided I was a strange, earnest man, not a threat. I was Kessler before law school, she said. Then I went back to my mom's name. Why? I told her I had a weird job and an even weirder story and that, for once, I didn't want to be the punchline. She laughed and said, I work in nonprofit compliance. I like weird rules. Order the fries. I did. Halfway through the second drink, my phone buzzed with a notification from the oh no script that I forgot to turn off. It lit up green. No hits. I breathed all the way down to the bottom. Update 4. 2 Mondays after the green light on my phone, I was in our GC's office with a cup of coffee that tasted like it had been filtered through a legal pad. She closed the door and said, IT wants to know if your little script is a real thing or a magic trick. I pulled out my laptop, opened the janky Python file with comments like do not sue me, and walked her through it. 10 minutes later, our IT director was perched in a guest chair, elbows on knees like a little league coach meeting a prodigy. By Thursday, they'd put it behind a firm login, slapped a real interface on it, and given it a name nobody liked, Intake Plus, because marketing hates joy. The malpractice carrier sent an email the following week offering a 2% risk management credit if we documented training and usage. I laughed so hard I had to sit down. The universe continued its dangerous experiment in making me a person with institutional knowledge. I got conscripted to a statewide CLE panel, big ballroom, bad carpeting, the whir of hotel HVAC, on modern conflicts in analog professions. I walked in to find the placard next to mine read Patricia, last name, and the moderator was one of our judges who has the tidy, surgical manner of someone who's cut through a lot of Gordian knots. Patricia didn't wave, just slid a paper cup of coffee toward me and murmured, they promised you'd bring a toy. I demoed the scrubbed version of Intake Plus and watched 200 lawyers, half of whom still print email, pull out their phones to photograph a QR code like it was a baby's first steps. The judge leaned into her mic and said, we will not be naming names. If you know a name, keep it to yourself. The ballroom laughed the kind of laugh that acknowledges a wound has scabbed. The line of people afterward was the same blend of curiosity and anthropology I've become used to. A mediator told me he'd started asking parties, what do your friends call you? At intakes. A public defender whispered that her office had already cloned the idea. Patricia stood at the end of the line and said, without her CLE voice, my associate called me Friday night to say your thing saved her from showing up to a first date with a guy whose ex has our client in a PFA. I told her she owed you a muffin basket. She paused, then added, I didn't write that blog piece. I would have made it punchier. We shared a cookie that came from a tray sweating under plastic wrap like it had been to war. On the personal front, the woman who likes weird rules still liked me after hearing the whole saga with both hands wrapped around a bar glass and her eyebrows trying to climb off her face. She laughed in the right places and didn't in the wrong ones. We went to a fundraiser for her nonprofit at a community center that smells like the ghost of last winter's chili cook-off. I bid on a basket with 2 theater tickets and 3 artisanal pickles because someone typed pickled experience on the cardstock and it made me want to spend money. Across the room, Patricia got into a bidding skirmish over a yoga package and looked at me with the exact expression you reserve for people you've deposed and now share a silent auction with. We exist in a tiny town disguised as a city. We lost the pickles to a realtor who clapped at himself. 2 days later, the clerk's office pinged me with a notice that a law school wanted the audio from the temporary support hearing for instructional purposes. An hour after that, my inbox dinged with an invite from a professor I barely remember. Would I guest in professional responsibility and talk about identity management and conflicts hygiene? I said yes, then immediately questioned all of my life choices. The classroom had fluorescent lights that hummed like a bee lodged behind your eye. I did my best not to be an exhibit. Halfway through, a kid in a zip hoodie asked if I ever thought about changing practice areas. I told him that was above his grading rubric. The wildest legal left turn happened on a Tuesday that already had too much caffeine in it. I'd cleared conflicts on a new divorce consult, a teacher with a retirement account and no appetite for blood, and was 10 minutes into our first call when Intake Plus popped a yellow box on my screen. Possible social overlap. First name, neighborhood match, historic app match. My stomach dropped in that familiar way. I scrolled. The name was one I recognized from a winter I've tried to forget, a dating app match I'd never met for drinks but had texted with enough to know she liked dachshunds, and hated kale. Not my potential client, the opposing party. I stared at the screen, at the little warning triangle that looked like a road sign for turn back now. I told the teacher I had a conflict and would have a colleague call her within the hour. I hung up, stood in my doorway until the carpet pattern started to look like a pointillist painting, and walked to GC's office. She listened, nodded, put it on the list for the weekly conflicts call, and told me, exactly this, is the point. The judge on the case found out 2 days later when she ruled on a continuance and thanked me on the record for identifying an appearance issue early. Tiny redemption, stamped with a docket number. Some things refuse to happen loudly. A postcard arrived from Portland with a drawing of a fox on a bike and 3 sentences in neat, small handwriting. The rain likes me. I found a corner coffee shop with terrible scones. Please take care. No return address, just the postmark and an ink smudge. I put it behind the private caution letter in my desk like they were mutually respectful roommates and closed the drawer. Because Balance is a prankster, a week after that I was served again, not a subpoena this time, but a notice of a motion to disqualify my entire firm in a different matter. Opposing counsel filed on the strength of pattern, by which they meant gossip. The brief cited the blog and 2 unnamed recent events, which I suppose makes me a genre now. We set it for a quick hearing. Same courtroom, new thin microphones. The judge, not my judge but a colleague of hers with a white streak in his hair that made him look like a cartoon barrister, asked precisely one question: do you have evidence of a current conflict in this case? When she said no, only concerns based on widely shared information, he said, we do not disqualify based on vibes. Motion denied. He didn't look at me when he said it, and I was grateful. Intake Plus started to feel less like my scar and more like a tool. Our associate orientation included it. IT added a ridiculous confetti animation when you get a green check after adding a new contact. An assistant in trusts and estate sent me a gif of a cartoon gerbil with the subject line, "Look what you did." The carrier came back with another email offering an extra half-point credit if we agreed to let them quote some anonymous lessons learned in a risk alert. I told GC they could write "do not date" like a golden retriever in 12-point font for all I cared. The strangest call came from Dave. Not a voicemail, a real-time, 2-person conversation that started with both of us saying, "Hey," in the exact same pitch. He said he'd referred a former coworker's sister our way and she'd landed with the colleague I'd sent his last referral to. I said, "Thank you." There was a silence that was not uncomfortable. He asked if I'd seen the appellate memo. I said I had. He said, "Footnote man." Then he told me he'd started taking a class on woodworking and made an end table that listed to the left. I told him I'd recently lost an auction for pickles. We both made a sound that, if you were a court reporter, you'd probably transcribe as laughter. When we hung up, I realized I hadn't felt like a disaster in his presence in a long time. On Friday, I took the woman who likes weird rules to a coffee shop that couldn't host a settlement conference if it tried. Baristas with forearm tattoos, cups with names written correctly on the first try, the hiss of steam loud enough to drown out self-recrimination. When they called out my drink, they used my last name with a soft question mark at the end, like maybe it was a story. I ordered the fries, because that is who I am now. Halfway through, my phone buzzed in my pocket. Intake Plus again. I glanced down reflexively. Green confetti exploded on the lock screen like bad fireworks. She saw it and said, "Does that mean we get to stay?" I told her it meant, for once, that the universe was going to let me be boring in peace. We split the fries with both hands. The only thing we argued about was mustard.